Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Welcome to Truth and Justice with Vivian King. We're going to talk about aggravated robbery tonight. We're also going to talk about aggravated assault on a police officer. We're going to talk about the common excuses police officers make to use force and the consequences once force is used. I have in the studio with me tonight an attorney by the name of Sam Milledge. Sam recently tried a case where a young man was charged with aggravated assault on a police officer. And we want to talk about the twists and turns that this case took from beginning to end. He's my only guest for tonight. Please watch it, listen, and learn. You know, the point of my show is to educate you about the criminal justice system in Harris County and give you an opportunity to call in to talk about this particular case because we want to know how you, the public, feels. We're going to jump straight in. Remember, if you want to call, please call us at 713-807-1794, and please stay on topic. This is a free speech show. We're going to talk honestly and candidly about the criminal justice system. I don't have a family member in the studio today, but Sam is going to start off by telling you what the police report said and the charges that he was defending. So, Sam, please say hello to my studio audience.
Hello, studio audience.
And my Houston audience. And let's just talk about this case. So let's talk about when it happened and basically what the probable cause said and what the police report said about what happened.
Yes, ma'am. This case took place in December of 2011, December the 31st, I believe, and right New Year's Eve. And I can remember that I was at a New Year's Eve party when I received a phone call from the young man's mother because I had represented a significant other of hers prior to that, and I guess we did a good job, so she called us back and she alerted me of this case and saying that it had been on TV. And basically, from what I gathered before reading the police report was that there was an alleged burglary of a motor vehicle that had taken place of undercover at one point. That's what the news was reporting. An undercover police officer at a Boudreaux's off of 249. And the police officer had shot at the suspect. Well, the suspect happened to be her son. And I talked to her and told her that, you know, we would look at the case and I would talk to her son. Her son came to my office and we signed a contract and we got started. He was doing court, I believe, January the 3rd of 2012, and we went to that court.
Now let me stop you there. So he was already on bond?
Yes, ma'am. He had bonded out. It was a $30,000 bond. He had bonded out, and his court date was set for January the 3rd in the 263rd, the Honorable Jim Wallace's courtroom.
And what was he charged with at that time?
At that time, he was charged with aggravated assault on a police officer, as you know, which is a first-degree felony. In our code, 5 to 99 years unless it's enhanced, which would then make it 15 to 99 years. But at the time, it was just aggravated assault against a public servant, and that was the only charge that we were facing. They, at that time, had not indicted him, but they were seeking to indict him in the coming weeks. Well, on our first day in court in front of Judge Wallace, the prosecuting attorney, which was William T. Exley, goes by Bill Exley, had said that he wanted to try to get the young man's bond raised because he felt like the bond should have been a lot higher based on a prior conviction. And, of course, we fought that. And the judge declined raising that bond, but what the judge did instead was place some unbelievable conditions on his bond, such as he couldn't leave the house but 2 hours out of the day, and that was just to take his mother to work and then pick her up. Of course, I had to come back and fight that, and he relaxed it reluctantly to 5 hours out of the day. And during that time, I knew it was going to be an uphill battle. And at this time, I still had not seen the police report, because anytime there's a police shooting, HPD treats it as a homicide. So then it has to go through the homicide division, which I'm sure you know can take forever and a day to get a police report. And thinking about it, I believe we went at least 3.5 to 4 months without getting a complete police report. But at this time, we were just strictly fighting the judge and these bond restrictions. And it was to the point that this particular judge felt the need to make comments basically insinuating that my client was guilty, just basically disregarding the main foundation that our system is based on, which is you're innocent until proven guilty. He made such statements as, well, innocent people don't get arrested, Mr. Milledge.
Okay, now let me stop you there. What I'm appalled about is that a judge's oath is to defend the Constitution. They raise their right hand. And a criminal judge particularly has to pay attention to the 4th, 5th, and 6th Amendments of the United States Constitution, and there are similar statutes in the Texas Constitution that mirror the United States Constitution. So, viewers, I want you to weigh in on when a judge tells a lawyer that innocent people don't get arrested, what is our system of justice based on, and what is his job based on? I mean, that's a deep, heavy response. I mean, a heavy comment to make. And remember, this is before Sam has ever gotten the police report. So you don't know anything other than what the probable cause says for the arrest, which is public knowledge on the news, and the news has it wrong.
Correct. The only thing that I knew at this time was that there was an alleged shooting by a police officer of a suspect. My guy was arrested some days later based on a quote-unquote anonymous tip to Crime Stoppers, and they picked him up from that. That was pretty much the extent of anything that I knew. And of course, like you said, the only thing that the judge was hearing was what the prosecutor was telling him. And the prosecutor, of course, which is his job, is to kind of slant the facts. And I had to keep reminding the judge, at this point in time, Your Honor, these are merely allegations. These aren't facts. And I felt that those restrictions that he was placing on my client was tantamount to incarcerating him before he even had his trial. So we fought that, and, you know, for the purpose of my client being able to work and, you know, being able to pay his lawyer fees, you know. So we fought that, and it got to the point where I had to recuse this particular judge because I did not feel like we were going to get a fair trial if I stayed there.
Now let me stop you there. Look into this camera and tell the audience, since it's an educational show, what recusal of a judge means.
Basically, ladies and gentlemen, what a recusal of a judge means is that I am asking the judge to remove himself from this particular case because he is showing an unnecessary and unfair biasness towards my client. He is not upholding his oath, as Ms. Vivian stated, as being an impartial, basically, referee of this particular case. So that's what recusal means. And
what were your issues to ask that he recuse himself?
My issues merely were the statements that he was making, which led me to believe that he was not going to be a fair and impartial judge in this case. Statements such as innocent people don't get arrested. When I approached about my client needs to work in order to pay his fees and the pretrial fees that you have him on, he said, well, what job does he possibly have? Probably a job that just lets him smoke weed all day. You know, things of that nature, which I thought were totally out of line for a judge to make. And the correct word is appalling. As a young lawyer, I'd only been practicing for a few years. I'd never heard a judge talk like that and bold enough to say that in front of a defense attorney or anybody.
The thing that's interesting about that is, and I'm very proud of you, Sam, for being a 30-year-old lawyer, I'm going to put your age out there, practicing 4 years and bold enough to write down, because most lawyers are scary, to write down what the judge said in a motion and say, because you made these statements against my client, I think that you should be removed from this case. And when you file a motion to recuse a judge, it actually goes to Judge Underwood, who is our regional judge that's over this region and several others, like Montgomery County. He's in Montgomery County. He's over Harris County judges, Fort Bend judges, Montgomery County judges for sure. I don't know all of the regions, but whenever I filed a motion to recuse a judge, I actually filed it with the court, like 263rd, where Jim Wallace is, and then I also sent a copy to the judge, Judge Underwood, up in Conroe, and called and asked that he actually preside over the hearing. Did you go that far?
I did. Based on, actually, I called you and asked you
I forgot.
your advice about that. I never was nervous about doing it. I knew the possible repercussions, but, and you know me well enough, I really just didn't care. You know, I had a job to do. My client was paying me good money to protect him and defend him. So whatever the repercussions were, whether he didn't want to be my friend anymore, I wasn't there to be friends.
Right.
But
you understand that a lot of young lawyers would be afraid.
I do, which...
I mean, those are your colleagues. So when y'all talk about it, what were they telling you? Man, you gonna do that? I mean, what were they saying to you?
Some were kind of hesitant to even tell me what I should do because they knew my personality. Some were like, man, I probably wouldn't do that, man. You know, you might create problems for yourself down the long run. But like I tell everybody, you know, I have a job to do. It ain't about my ego. It's not about making friends. I can care less about making friends. I have more than enough friends.
And you're so much like me when I was a young lawyer. A lot of times I'm told to be a troublemaker and prosecutors don't like me. But, I mean, when I was a prosecutor, I did my job honestly. And as a defense lawyer, I do it honestly. And this profession, we should treat each other professionally. And one of the things I've always been shocked about this profession, because I was a banker for 9 years, people say the right things to each other. Mm-hmm. They don't say things to your face in the banking world with the blue suits that are unprofessional. Right. But when I left banking after 9 years, you know, out of college, and then I go to law school and come here, I'm thinking I have more education. I'm about to be around more educated people. And people are calling people poor white trash. They're saying the N-word. And these are educated second and third generation lawyers, and I mean, lawyers' kids, doctors' kids. And they're talking about people as DAs. They're talking about people and talking about them ugly. And the judges are saying nasty things. And so it's actually very shocking.
It is, and it goes both ways, because I know there are people that talk about DAs, and again, at the end of the day, everybody has a job to do, and I respect that. I expect for the DA to do his job to the fullest. I would hope they expect for me to do my job to the fullest.
Okay, so let's move on.
So basically, we got to recuse. The judge recused himself. We didn't necessarily have to go through the entire proceeding.
So basically, he reads the motion and just, oh, I agree, and just signs off.
He signs it. I guess he didn't want to go through the hassle of that. And it gets transferred, and I was kind of surprised. I thought maybe it would get transferred to a judge that's nowhere near him, but it got literally transferred right across the hall to the Honorable Denise Bradley. I never, other than just covering for some attorneys, you know, filling out some resets, I never had any encounters with Judge Bradley with regards to trying any cases there. And my first impression of her was that she was a nice person. Very friendly, very personable. And I was like, okay, well, this wouldn't, you know, this is not going to be a bad deal. But something my dad always says, you always want to go with the devil that you know. And this couldn't be any truer in this particular case. So gets transferred to Denise Bradley. At this point...
And that's the 262nd?
262nd, yes, ma'am. At this point, probably a week after the fact, we get the offense report. We get this offense report that's not even in an organized fashion. It's discombobulated, so I have to go through, it's probably like 100 pages. I have to go through and figure out, okay, what page comes next? Okay, you have paragraph on page 1 that may not pick up until page 4. You know, and it was just, I don't understand that, but the explanation that I got was that's how the computer at HPD printed it out. So nevertheless, I was able to make sense of the offense report, and at this time, my client's still just charged with aggravated assault against a public servant.
Has he been indicted yet?
He's been indicted, okay? He's been indicted, and...
So he gets indicted before you get the police report?
He gets indicted before we get the police report.
Wow.
I found that odd, but he gets indicted before we get the police report. And I get an initial offer of 25 years, excuse me.
So you get an offer of 25 years in prison. Your client is walking around on bond, and you have a 25-year offer. So what does your client say to that?
Some things that I probably can't say on TV, but to make a long story short, he says no. I mean, and I understood that. My client, at the time was just 24 years old. Oh, I'm sorry, 23 years old. So, you know, of course he doesn't want to spend the next 25 years or at least 12 years of his life in TDC. So I politely let the DA know that that's unacceptable. And one of the things that I was able to look at once I got the offense report was they did not have fingerprints matching my client, and I'll get to why that's important.
Give me a few lines, though, about what the police report said his conduct was to support an indictment for aggravated assault on a police officer.
In a nutshell, this particular police officer, he wasn't undercover as the news was reporting. He was actually off duty, eating lunch at this Boudreaux's Cafe off of 249 Tomball Parkway with a female acquaintance. We don't know whether or not they were dating or whatever, but it was about 4 o'clock in the afternoon, and as they're leaving, according to the offense report, he sees a black male, and I'm going to throw this word and use the air quotations, black male, because that's the only way that my guy's identified, is just a black male. He sees a black male rummaging through his trunk. He then realizes that someone is breaking into his car. He runs up, allegedly screaming, "Police, stop." This particular person who's rummaging through his car, as he says, turns, looks back at him, slams the trunk, jumps into a car that's parked right next to his car. Now, his car was a Dodge Charger. The particular car that he alleged that the suspect jumped into was another Dodge Charger, but that was backed into a parking space next to his. So he goes up to that car. He says that he's able to see the guy after telling him that he's police. He sees the guy comply, put his hands up. Then he says all of a sudden the guy's hands drop down and reach for what he thought and what appeared to be a gun. The car then drives forward. He's in between the two cars.
Now, which one is in between the two cars?
The police officer. The alleged suspect is back in the driver's seat of the car, the getaway car. We'll just call it
so
that.
the suspect's hands are up in the driver's seat.
In the driver's seat. Okay. And it's important to mention that in the offense report they state that the car had dark tint on it.
And this is nighttime?
No, it's about 4 o'clock in the afternoon. But the car has dark tint on it. We don't know how dark the tint was, but dark tint. And he's able to see through this tint. A person put their hands up, then drop their hands, reach down and allegedly pick up a weapon. At this point, the car starts to drive forward to get out of there. The officer shoots at the car 4 times. The car leaves the Boudreaux's parking lot, driving the wrong way on the feeder of 249, hits another car, somehow gets up on the ramp and takes off. But 3 days after that, we have news reports saying that it was a black Charger. No, it went to a gray Charger. Then it went to a tan Charger. So we had 3 different colors of this vehicle. The only identification of the suspect that we had, only description, shall we say, was just a black male. Now, I went with that. That was the only thing that I had, and that was what they said in a nutshell. And the officer gave a statement, and he identified the suspect as just a black male in his written statement prepared by or in front of Aaron Suter, who's I guess the union attorney for the Houston Police Department. Somehow, 3 days after the fact, he's able to ID my guy in the photo lineup. And coincidentally, it comes literally an hour after this anonymous tip comes in, saying that my client and another person were involved in a shooting near Willowbrook Mall. So now this guy comes in and IDs my guy. But they take fingerprints because the crime scene unit goes out there and says there's an obvious latent print. And what a latent print is just basically a fingerprint that can be lifted and read and detected somehow. And, I don't claim to be a scientist, so I don't know necessarily how it works, but if it's obvious, that means that there's a fingerprint there. They take this fingerprint and they run a test on the fingerprints to see if it matched my client, and it did not match my client.
Wow.
So having read that report, of course, I refused that offer of 25 years, and I explained to the prosecutor that you guys are going to have a problem with this case. One of the elements of aggravated assault against a public servant is that the defendant must know that the person is a police officer. This particular individual that was the police officer was off duty. He was in clothes, a checkered, looked like somebody's tablecloth at a picnic type shirt, some blue jeans and some Air Force Ones. So to the average person, you wouldn't know he was a police officer. The alleged car that was getting broken into was just a plain Dodge Charger. you wouldn't know that it was a police officer's car. So I felt like they were going to have problems with that. More importantly, you did not have fingerprints suggesting that my guy was there. You also, the only description that you had of my client was a black male, and it's important to know that my client is very distinguishable. He is tatted up from head to toe. I mean, he even has a tattoo that says a curse word, F friends, basically. Mm-hmm. So if you see this guy, anybody that meets him for the first time, that's the first thing they say. I know when he walked to my office, my dad was like, boy, that guy has a lot of tattoos. Our investigator that we hired, Mr. Shelby Stewart, man, that guy has a lot of tattoos. Even when we got to trial, the other officers were like, yeah, he has a lot of tattoos. I would think if you properly identified somebody, you would be able to point that out. That's a distinguishing mark. And I thought it was kind of unfair and really lazy just to say a black male. This is Houston, Texas. We have one of the highest percentages of African Americans, let alone African American males in the country. So my argument was, well, I'm a suspect. My father's a suspect. My cousin's a suspect. That's unfair. So we refused to offer, and once we got over to Judge Bradley's courtroom, the DA was a little disappointed that we did not want to take that offer, and so he advised me that he was going to seek a second charge of aggravated robbery. And when I asked him why he was going to seek the second charge, well, because I wanted an insurance charge. I feel like there's a possibility that I may not win on this aggravated assault against a police officer. I get that. But I feel like I have enough here to get an aggravated robbery. Mind you, in all the statements in the offense report, there was never a word or statement about any property being taken. Now, that's not what they were charging. You know, that's not what they were really fighting. And the judge basically told him, and this was about 6 months after my client had initially been arrested and given bail, the judge told him that if you're going to indict him, you need to go ahead and indict him like yesterday. And so he said...
And that was talking about the second indictment.
That was talking about the second indictment of aggravated robbery.
Now, how did the judge get involved with whether or not there were going to be a second indictment? Did Bill keep trying to postpone setting it for trial because he said, I'm going to charge him with something else? Or, I mean, why did the judge get involved with that?
Well, Judge Bradley felt like the case, for some reason, had been going on for too long. You know, I don't think, like I said, the case had only been 6 months old, and in Harris County, that's a rather young case. And I'm sure you can attest to this, but a lot of times with felony cases of that nature, it may be 2 years before it goes to trial. But she's known as having a rocket docket, as they say, and she was asking what was going on. And so then in front of her, Bill said, well, I plan on indicting a second charge, and I've, you know, expressed this to Mr. Milledge, and I said I was aware of that, but I was prepared to argue against it because I felt like if he was going to charge that, he should have charged it a long time ago. And I think he's only doing this, you know, out of spite, and this is basically malicious prosecution. But the judge instructed him that if he's going to, and she was pretty upset about it, if you're going to indict him, you should have done this like yesterday. And so he indicted him. I stayed up to about 4 in the morning preparing grand jury packets, something I've never done before. I don't know if I'll ever do one again, but I felt like it was worth doing because I felt like it was just wrong. And
what did you say in the grand jury packet?
Basically, I laid out my facts of the case, and I basically pointed out the fact that, one, there are no fingerprints matching my guy at the scene, which they have taken. The only description that they give of the potential suspect is a black male. My client, I included a picture of my client. My client has full of tattoos. I also included a portion of his written statement saying, you know, making no mention of any property being taken. And
now when we say he, you're talking about the police officer?
That police officer. Police officer or his female acquaintance that was riding with him.
And they actually give handwritten statements?
Yeah, they give written statements.
And they gave both copies to you?
They did, gave written statements and recorded statements. And
no mention of anything being taken?
No,
wow.
Not at all.
And the grand jury still indicts?
Grand jury still indicted him, which was disappointing. And
did Bill personally take it in, or did another prosecutor take it in?
You know what, to be honest with you, I don't know. I just remember getting up there early in the morning because he said that, well, let me get your stuff, and I'm assuming he personally took it.
I think so. If he's trying to get it indicted for something,
right,
for something that's not mentioned in the police report.
Right. So, you know, I can't say with 100% certainty, but I do believe that he personally sought to get it indicted and did do whatever to the grand jury, and he got it indicted. The issue that created was now my guy was already on a $30,000 bond. And with this new charge, now he's on a $50,000 bond.
So he gets 30 plus 20?
No, 30 plus 50.
Okay, so now he gets a second $50,000 bond.
Second $50,000 bond.
And most bondsmen charge 10%. So he's already paid $3,000 to a bondsman, so now he's got to pay $5,000.
On top of paying me.
On top of paying you to stay free on the same police report with no new allegations.
Well,
right?
Yes, with no new allegations. And
we have a call. Can we stop right here?
Sure.
Okay. Caller, you're on. Please turn your radio down and talk directly into the receiver.
Very good. I just turned your program on. I have to admit I did not hear the entirety of this conversation, but just as a layperson, I'm not an attorney, but as a layperson listening to this discussion about this person, sounds to me, and I'll be very frank, sounds like this is almost like a game between the professional criminals who try to go through the system, which they're very familiar with, and the attorneys who are very familiar with the system. And it sounds as if without one or the other, it wouldn't be any fun, because you have a person who was arrested, obviously, for some type of robbery of some kind, and the only description given was a black male. Now, I wasn't arrested that day, and I know a lot of black males probably weren't arrested that day, but this particular person was singled out as the perpetrator of this crime, and he was, according to, I believe you, as innocent as a newborn baby. But how did he get in the mix of all of this if he didn't do it? Was he at work that day? Well, he probably wasn't working, so he doesn't have an alibi that way. Was he doing volunteer work somewhere where people would say, no, this gentleman was here all day, so he couldn't have done this crime? No, he probably wasn't there. Was he with someone that could vouch for him? A relative or close friend, perhaps? No, because probably they didn't want to get involved. My question is how do all these innocent people get caught up in the system if they didn't do anything?
That's a good question. Thank you for calling. Let's move on to the case, please.
Okay. So basically now we have two charges that we're fighting, and my guy has two bonds. He went on the run. Basically, I didn't have any contact with him. He would call me, but I didn't, it was just more so of, hey, man, I'm going to have somebody bring you money, just let me know when trial is. And I understood why he went on the run, although
So he stopped coming to court. Did he make the second bond? He made the second bond. Oh, he didn't make it. So when he found out that the prosecutor charged him with another crime.
And then got it indicted.
He
took matters into his own hands.
And he just stopped showing up because he knew he'd be arrested and couldn't make a second bond.
Right.
Wow. Okay, so I'll show up for trial knowing I'm going to go to jail.
Correct. Okay. Correct. So speed the things up. The offer then goes from 25 years to 60 years.
60 years, okay.
And I asked the prosecutor, what is it that you really want from my client? And the prosecutor's exact words were, I want your client to die in prison. And he not only said it once, he not only said it twice, but said it numerous times. I want your client to die in prison. I feel like he's the reason why prisons were made. Now, my attitude was, I like my chances better than yours in getting 60 years. I mean, we might as well go to trial. We don't have anything to lose. And so we went to trial in early January of this year on both charges. And it was a very long trial, about 7 or 8 days, because the state called up numerous witnesses. I only had one witness, which was my investigator, that uncovered some things. And one of the things that he uncovered was on the dispatch tapes. We had subpoenaed the dispatch records, the 911 calls from that particular day at that particular instance. And again, we had that particular officer say that the car was gray. Then we had another officer say that the car was black. Then we had a third officer say, no, the car is tan. And the dispatch lady said, guys, one of y'all saying black, one of y'all saying gray, now y'all saying tan. What color is it? Then we had somebody call in on dispatch asking, well, do we have a partial license plate or anything?
Now, what color was the officer's charger?
The officer's charger was gray. The officer's charges were gray. But they didn't have a license plate. We exploited that. They didn't have, you know, no description other than just a black male. And I got the officer to admit that only thing he knew was a black male. And I asked the officer, I said, well, he didn't have on any clothes that day? Was he just as naked as a jaybird? What did you see? And he just kept saying, all I saw was a black male. What really swung the tide of this case was his relationship with the particular acquaintance. Jurors have this quirk that I've seen about people lying about or not telling the necessary truth about the smaller things, the inconsequential things. We had asked him how long he knew the particular young lady he was with, and he said a year and a half. Well, the state called up the lady, the female acquaintance, right after him, and they asked her how long did they know each other. She said 5 years.
Wow.
And so immediately eyes and heads perked up looking. So we exploited that and we hammered that home. And in my closing, I told him something that my grandma used to say, you know, if I can't trust you about the little things, how can I trust you about the big things? And the jury bought that. Throughout the entire trial, there was really, the focus of the state's case was on the aggravated assault against a public servant. I'd say maybe 5% was dedicated to the aggravated robbery. And that 5% were things that were not mentioned in the offense report, such as, well, I saw the guy with a wallet in his hand. My cousin's wallet was missing. My cousin's wallet was in the car that day.
So the cousin wasn't even there?
Cousin wasn't even there.
Wow.
And I asked the officer, I said, why would you have your cousin's wallet? And he couldn't, well, it was just in there. All of a sudden, a makeup bag was missing, a pink makeup bag. And the female acquaintance testified that she didn't know that the bag was missing until the officer told her that the bag was missing. So we had a lot of things, and I asked the crime scene unit guy, well, how come you didn't document this missing stuff in your report? He couldn't give me an answer. Well, it's just not in the report, but I do remember them saying that. I said, but you didn't put it in your report. Isn't your job to accurately reflect the scene as you know it? When I asked the lieutenant that was doing the investigation, I said, did any one of them give you a statement about any missing items? He said no. So I felt like we had a good case. We had two good cases, and I expected to get not guilty verdicts on both of those. We ended up getting a not guilty verdict on the aggravated assault against a public servant. However, my client was found guilty on aggravated robbery, which was disappointing and very disheartening.
Let me stop you for a moment. What did you find interesting? And I wonder if some of my viewers, and you're welcome to call in and talk to me about that, find it interesting that a lawyer is fighting an aggravated assault on a peace officer for 6 months, and then the DA says, well, I'm going to get him on something, so I'll charge him with aggravated robbery, when nothing about robbery was ever mentioned before. I find that unfair, and as a lawyer, that's very difficult. I didn't respond to the caller that called a minute ago because he was, it's a free speech show, and I don't mind your free speech caller, but nobody was at work that day, not the police officer either. He was on a date. He was off work. It was at a time when no one is at work. So to call in and talk about, well, your client wasn't at work, he didn't have an alibi, and all of these things is interesting for you to say, and therefore I didn't think it justified an answer. The officer called himself an officer because police officers say they're officers 24 hours a day, just like I'm a lawyer, and I could say I'm a lawyer 24 hours a day if it gains me another charge, I guess.
Well, actually, my client, as a black male, wasn't arrested that day either, and I was going to let the caller know he wasn't arrested until 3 days after the fact. And as I stated earlier, and he did admit that he missed part of that, our discussion from earlier, maybe that's one of the things that he missed. It wasn't until some anonymous tip came out naming my guy, and of course there was a reward associated with this tip.
And the thing that's always interesting about an anonymous tip and a reward is that if a person knew who did it, they should have called the police right then and called 911. Or is this someone that's trying to just get some money?
Right.
You don't know if it's true or false.
Right.
So that's one of the things you called. And, caller, if you or your child gets charged with the crime, you would want the Constitution to work. You would want the 4th and 5th and Sixth Amendment protection. One of the big dichotomies in practicing criminal law is we hate everybody else. We want everybody else. We want to spend our tax dollars putting people in jail for $30,000 to $50,000 a year, as long as it's not our children or our loved ones. Because if a police officer gets charged with a crime, they come in and they want the best lawyer money can buy also. And so let's just look at the system objectively and talk about what goes on in the courthouse. Neither Sam nor I are saying anything is right or wrong. This is a show in which I produce and pay for to let you know what's going on, the side that the news is not giving you. The news talked about a lie. What was reported on the news didn't happen, because usually if a crime occurs, the news is not, the witnesses are gone, they've gone to talk to the police. If anyone gets killed, they're at the hospital. So they just talk to all the passerbyers. And so a lot of times the things that we create judgments for are not the facts. Because in this case, what did the news say? News said, one report said a black Charger left out. The other said a light-colored Charger. One said a tan Charger. So you're right. And it didn't report a robbery. No, it didn't. It didn't report, the news didn't report a ag assault on a peace officer, did they? No. And so what he was fighting was something totally different than sensationalism of the news. My show is to discuss what happens honestly and let the chips fall where they may, because they do. Right, right. And they did, and it was, like I said, unfortunately. So because the police report was all about the ag assault on a peace officer, and this is supposed to be him reaching for a gun. Allegedly reaching for a gun, and then they tried to say that my guy, if he did not reach for the gun, well, then the alternative was he used the vehicle as a dangerous weapon in trying to run the officer over. And, of course, we hammered home the fact that the officer did not necessarily see a gun. He just assumed, and you cannot assume. And, you know, we talked about this earlier. That's a common, I don't want to call it an excuse, but that's a common reason that officers use, which allows them to use deadly force. And I'm the first person to say, as a police officer, it's a very dangerous job. And I want to make no mistakes about it. There are more good police officers than there are bad police officers. And I commend them for what they do, because I wouldn't want to be a police officer. It's too dangerous. But I think sometimes, and what we've seen here in Harris County, we see a lot of police officers claiming, and it's kind of like the standard company line. I thought I saw what appeared to be a gun, thus I shot my weapon. Right. Let's take a call and then let's pick that conversation up. Caller, you're on.
Hello.
Hello.
Outstanding show.
Oh, thank you.
It's a little bit hard to follow since there's so much going on, but I don't think the recused judge was expecting so much grit in a young lawyer.
Can you imagine a young lawyer like him? I'm so proud of him.
And imagine an older lawyer doing that.
I know, it's amazing. I'm very proud of him that he would have the balls, I guess, or the tenacity is the proper word.
Naming names and places.
I know it, to tell the judge, you said this and you were wrong and you're not going to give my client a fair trial. Took a lot of nerve, and I'm very proud of him for that. In fact, I'm going to try to see if he'll help me on a trial next time. I just had a great one last week, but I will ask him. Thank you for watching, and we'll continue this conversation.
One more comment, please?
Yes, sir. Yes, sir.
The lineup didn't seem kosher. I don't think the arresting officers are supposed to be involved in the lineup. Is just as per new federal guidelines or whatever. And just multiple other stuff that I've heard in Samuel's presentation that just didn't sound right. And it's important that he got him off of the aggravated assault of an officer. That was a big win. What do you think about the fact that the police report mentioned nothing being stolen, missing from the car, but yet they don't have a fingerprint? No fingerprint, but the jury compromised, because after the trial they told Sam that they basically compromised. And how did he get in the trunk? And, yeah, but nothing was taken. And so even if they feel that he was the same boy, the young man that went in the trunk, it's not aggravated if someone sees somebody in a car. You know, the aggravated is you show or exhibit a weapon to actually facilitate the crime. Otherwise, it's just burglary of a vehicle, you know, and that's
Is that still? It was a misdemeanor. Is it back to being a state jail felony?
Well, it's a misdemeanor, but it's enhanceable depending on how many you have prior to that.
Right.
Which
So it's a misdemeanor. If someone breaks in your car, it's a misdemeanor where it's up to a year in jail and a $10,000 fine. So that's what the actual officer saw. And an actual normal citizen, if sees someone breaking in their car, would run out, call the police, but they wouldn't pull a weapon. The interesting thing about this case is once an officer pulls a weapon, even though he's not an officer at that time, literally, because he's not on the payroll, they're going to usually shoot at you because that's the way they're trained as police officers.
Usually they say the getaway guy swerved at him. That's their justification for discharging a weapon.
And that's exactly what they were saying.
Was that the case here?
Oh, yeah, he just said that. That's funny you said that. Sam said that that's what they said.
That's exactly what they were saying, sir, with regards to that, because they knew trying to say that my guy had a gun wasn't going to fly because he used the words "I thought" and "it appeared." So they tried to say that the weapon that was used was the vehicle that allegedly my guy was driving.
So in the indictment, they alleged that the deadly weapon was the car.
The vehicle or the gun.
Oh, so they listed both, like vehicle or gun we didn't see.
Yes.
And see, the thing that makes it difficult in Sam's case is that the officer was not on duty, so he was just on a date. And usually you can't make your dates lie. You know, the thing is, if it was all police and he was on duty, all the police would have had the same story, that they saw a gun. You see what I'm saying? Mm-hmm. But once he had a civilian with him because he was off. So therefore, you can't make the girl say something different. And so therefore, the officer has to say either one. We'll talk about it some more. Call us back if you like.
I know you aren't finished talking about it, and it's a great show. Thank you.
The thing that I find interesting is that one of the things Sam and I talked about before we started on air is that I personally understand also that being a police officer is a very dangerous job. It's a job I would not want, shooting at people. It's dangerous. It's scary.
It is.
But one of the things I wish I could see is that if that officer did the same thing that he did, he's not at work, he's off, but he's always a police officer, even though he wasn't on the payroll at that hour, saw someone breaking in his car, went out there with his gun to protect his property, and shot at the guy because he thought the guy might be reaching, even though he didn't see it, and just told the truth. But what officers do is every time they shoot at you, because they shot at the car, they file charges on someone to justify what they did. But the public would support them doing it even if it was a mistake. You know, that's what I'm offended by, is tell the truth. Because I think that if I was a police officer and I'm pursuing someone that I think was breaking in my car and I saw him reach down, I think I'd shoot at him too. Right. I wouldn't wait. Right. But the difference between me and the police officer, me the civilian, putting myself in the shoes of a police officer, I would tell the truth. I thought he had his hands up. When he put his hands down, I did not know what he could have come up with, so I shot at him. Right. I would have just told the truth, because you can use force in pursuit of your weapon if you believe they're using force. And so the public would still support an honest police officer. You don't have to write the same script. Every time you fire your weapon, say that somebody shot at you and put somebody in jail. Right.
And I think he told the truth to an extent. I think where the lies come in is whether or not he saw my guy.
Right.
Because I think had he seen him,
he would have seen this tattooed face.
Right, and you would have been able to give in 4 different statements. You would have been able to give more than just a black male. Right. And that's the thing that more so bothered me. I don't doubt that he felt like somebody was reaching for a gun, like you say. And had it been me, I probably would have done the same thing. But if I know I did not see the person, I would have just said, you know what, I really did not get a good look. All I know is a black male
driving this kind of vehicle.
Right, that's all I know.
And put that out on the news and let Crime Stoppers do its thing.
Right.
But don't lie about the identification. Right. That's the thing that's frustrating for defense lawyers, because we might know where the person was. We might know. But the problem is the cards are stacked against you. And then when you get a prosecutor that's, okay, well, even if this doesn't stick, the actual allegation that Sam's been fighting for 6 months doesn't stick, I'm going to now say something was stolen. And they know that these jurors in Harris County are going to support you saying something was missing that you never reported and you never put in the police report. Basically, our county agrees with police officers lying to them. Yeah. Because the lady didn't know that. She didn't say anything was missing.
No,
she
she didn't.
She was honest.
She
didn't. She said, I didn't know anything was missing until he tells me my makeup bag is missing. Well, that doesn't make any sense.
And I felt so bad for her
because basically she has to help her boyfriend lie.
Right. Well, acquaintance as they call each other. But I felt so bad for her because she really was trying to be an honest, neutral person. And I'm not saying that this officer was a bad guy. And the caller brought up a good point about the identification, because I told the jury basically, look, if the police want you, they'll find out a way to make you be that person.
Right.
No one's in that identification room. Of course, there's supposed to be procedural safeguards to cut down on suggestive identifications. And like you said, the arresting officers could not be there. However, the investigating officer was the one conducting the photo lineup. And see, I had problems with that. You know, I felt like it should have been somebody totally independent.
Now, when you say the arresting officer, what do you mean? The actual officer that did the shooting?
No. He was the guy that ID'd him, but the person conducting the photo spread to him, laying out the photo spread, saying, okay, which one did you see? You know, that person was the lead investigating officer, the person that also had received this quote-unquote tip. And I had issues with that. I felt like it should have been someone totally independent, someone that's not in the homicide division that he works with, because he was a homicide officer. Should have been somebody else that came in and just like, okay, who did you see? That way it would have cut down any suspicion of any type of wrongdoing and suggestiveness on the photo spread.
So the officer that was off duty was a homicide officer?
Correct.
Wow. Do you know that the judge's husband might be a homicide officer?
I didn't know that until after the
Wow. Okay. Hold on. Let's take a call. Caller, you're on.
Hello?
Hello. Thank you for calling.
Yes, I called because I was watching your program.
Yes, sir.
And for my opinion, I'm not saying, what's right and what's wrong, but I don't feel that, I feel that they're wrong because no one have any evidence or anything to prove that this is the guy. You know, that's just like going over to Africa and saying it was a black man. Well, hey, 90% of the population is black, just like over in Houston.
I agree with you, Colin. That's where we get into our racial divide in Harris County, because being a black person, we understand that, and the prosecutors, if they're white, don't, unless the defendant is white. And there are white defendants, but then when the defendant becomes white and looks like them, then they have a better understanding. So it's unfortunate that we don't admit our racial divide, because it's there and it's real, and that we don't try to discuss it honestly and try to overcome it.
Yeah, because I'm dealing with that same problem. I've had so many problems with HPD and stuff like that. Accused me of doing things that I was innocent.
Well, always fight for your rights, sir. If you're not innocent, if you're not guilty, don't plead guilty to a crime that you didn't commit. That's what so many people do, and that's why we have a system of prosecutors that expect you to plead guilty. Mm-hmm. We have a system now where you're guilty until proven innocent, and that's very difficult to deal with. We have 10 more minutes. Do you have another comment, sir?
Yeah, but see, like I was arrested. I mean, I was put in jail. And after I got out of jail, the judge told me he didn't care if I was guilty or not. As far as he was concerned, he was going to get me. That's what the judge told me. So, it's really hard to win when the system is against you.
Well, we are the system, and we can go to jury duty. We can demand that the system be fair. We can all go as black, whites, Hispanics, Asians, and demand that the system be fair. We can be fair and impartial, listen to the facts, and treat people the way you want to be treated on both sides, whether it's the police or the accused. God bless you, and let us wrap up the show for tonight. All right, we have 10 minutes. Golly, it's going so fast. We might have to do 2 weeks. You might have to come. Do you think you can come back next Wednesday?
I can come back. I can make it happen.
Well, I'm going to change whoever I have next Wednesday, and we're going to follow up with this, because we have a lot more to talk about this case study.
Right.
There's a lot more to it. So I don't want you to feel any pressure. We have 10 minutes to keep it going, but there are a lot more twists and turns to this story. Yeah,
there are, and I will be more than gracious to come back, and I appreciate the offer.
Okay, so let's keep going.
Well, basically, like I said, my guy got convicted of the aggravated robbery, and what turned the case, in which our callers do not know, my guy, when he was arrested, there was as they tried to deem it, a confession tape, but he never confessed to doing anything. What he said was he was there at the scene, but he was not the person driving. And we filed what's called a motion to suppress to try to suppress those statements from coming in because my client had invoked his right to counsel.
Now let me ask you this. Now when he said he was there, was he saying he was a passenger in that Charger?
Correct.
Okay.
He was saying that he basically admitted to
being there.
Being there.
And let me just tell you this, callers, mere presence is not evidence of guilt.
Right. He admitted to being there, but as he stated in the tape, he wasn't the person outside rummaging through his trunk, and it was impossible for this officer to see whoever it was because everything happened so quickly. Nothing was taken. You know, he basically said, I didn't do what they're claiming that I did. I'm not the person that you're looking for. We tried to suppress those statements because I knew that if that statement came in, there would be some type of prejudice against my guy for just basically being guilty by association. And our grounds for suppressing those statements were that he had invoked his right to counsel. When they read him his Miranda rights in the confession room and asked him did he understand his rights, my guy's exact words were, yeah, but I need my lawyer to come talk for me.
And that's on the tape? That's
on the tape because these questions are going to be tricky. The officer then immediately replied, no, these questions are not going to be tricky. I'll just let you talk. So how do you want to do it? And there's silence for about 15 seconds. And finally, my guy just says, I guess I'll let you guys ask the questions. So
I have to admit, Sam, under the law, that's kind of like what did they say?
Well,
I hate that. I mean, I've had to do that too, is that the law used to be, as soon as someone says they want a lawyer, the officers are supposed to stop.
They're supposed to stop.
They're supposed to stop questioning you and let you go call a lawyer, reset the interview date. But, of course, you know, the law that was the law that had to do with the 4th, 5th, and 6th Amendment has been relaxed through the years depending on who our Supreme Court justices are.
Right.
And so now they're saying that was the law when we went to law school, but now the law is
it has to be unambiguous,
unequivocal, and if the client initiates the next conversation, then they're giving up their Miranda rights.
Well, our argument against that was that when a person says, "I just need my lawyer to come talk for me," that's unequivocal. That's unambiguous.
I agree.
He did not initiate the conversation. The officer's next words were, no, these questions are not going to be tricky. I'll just let you talk. So how do you want us to do it? We can ask you questions or you can just talk. Which one?
So did Judge Bradley get to hear that tape?
She did, and I actually had the tape transcribed by an independent transcriber that did a very accurate job in reflecting that, and she somehow denied it.
Did you make her actually watch it so you could... Was it video?
It was videotape.
Did you make her watch it so that she could see his body language?
Yeah, I made her watch it. And you could see him shaking his head like, no, I just need my lawyer to come talk to me.
Let me tell you what's interesting about that. I had a federal case in 1998. I was representing a guy affiliated with Rap-A-Lot. Had the same thing happen, similar, where the guy gave the statement. He gave a long confession or whatever, or told what happened. And at the beginning, he said, I thought my lawyer was going to be here. And the cop says, no, we talked to your lawyer, and your lawyer said he's in trial somewhere else, so just go ahead and talk to us. And that federal judge threw that statement out. She suppressed it.
Oh, yeah.
Yeah, because he went ahead, he said, okay, well, if that's what my lawyer said, I'll go ahead and do it. And the lawyer had really done that. I mean, the lawyer had really said, y'all could go ahead and talk to him. But in Harris County, in fact, the judge threw that statement out. We ended up going to trial without the statement. The judge gave a Rule 29, basically a directed verdict in federal court. And then the cops were so angry because he was looking at federal life, and he got found not guilty by the judge. She took it away from the jury. The case was refiled in Harris County in the 180th, which was Debbie Mantu Strickland at the time, and I just said she'll never grant it. So do you want to, the same law, same statement, DEA, angry because they didn't get a conviction. Now they're forum shopping. They come to another forum, and I say, I think we ought to just plea bargain. You're 25 to life here. We got him 12, and just do the time, because you're going to end up going to trial. She's not going to grant it. And because of what the crime is, you're going to end up getting 50 years, and I just don't want to see that happen. So I had to tell him to go ahead and take the time. He's out. He's been out for years, got a great business, and he's doing well.
Right. That was, yeah.
But I mean, just telling you, the difference between federal and state is because in state court, the judge, I know she would have she had never granted a motion to suppress at that time.
Right.
I knew she wasn't going to do it. The same law, same constitution, but just a different attitude.
Right. Well.
And it was the same attitude.
And that's unfortunate, but that's what we deal with.
But you have to deal with it.
Right, we had to. And the sad thing about it, and there's another caveat to this story. At one point, the prosecutor said he wasn't worried about the statement when I had filed a motion to suppress. I'm not going to be worried about that, but I feel like once he saw that the case was slipping, he went back on his word, and he brought it in, which was fair. He had every right to do that. But I felt like Judge Bradley, in looking at the tape, looking at his body language, listening to the words, also comparing the transcription that we offered. The state tried to say that it was an accurate transcription, but they didn't bother to get it transcribed themselves. So you only had my transcription, you had my tape, and you had my memo. And the state didn't give anything.
Because they don't have to. Because all they have to do is say, Judge, do it our way, and that's all that happens.
The state didn't give anything, and she ruled against us. And those jurors that I did talk to admitted that's what turned the tide and got the conviction for the aggravated robbery. Although they admitted most of the case was focused on aggravated assault against a public servant, and it is kind of strange that they didn't mention, in all this time, didn't bother to do a supplemental narrative. You didn't mention anything being taken. Why all of a sudden now?
Man, I don't understand why that wouldn't do violence to your conscience as a juror to convict someone when you know that there was a 6-week or 6-month investigation with a 100-page police report and there's no mention of anything being taken. But yet the officers can come to court and all of a sudden now say something was taken. And even his acquaintance, female acquaintance, says, I was not missing anything, but he told me that I was missing something. And the jurors still felt pressured. And I just wish the pressure to police officers would be to be honest, because we are going to support you honest just like we support you being dishonest. Because those officers, I mean, those jurors had to know that.
Well, what did him in was not telling the truth about how long he knew the young lady. And it could have been an honest mistake. Maybe he took the question to mean, how long have we been dating? But she took it as, well, I've known him for 5 years.
Right.
And like I
and like you said, he could have just meant he knew her for 5 years, but he only had been seeing her romantically.
Right, but that was a huge discrepancy.
Yeah.
I can see if you said, well, I've been seeing her for 2 years, and she says a year and a half. Okay, but 5 years, a year and a half.
That's a big difference.
People were like, wait a minute now. So, I mean, it's just one of those things, and I guess I know we're running out of time, but
We have 1 minute, and I just want to know, let the audience know we're going to continue next week, but his client got 28 years. 30 years. Okay, I keep
30 years.
So he got 30 years.
As opposed to the 60 in life that the state was asking for.
Right, so he got 30 years, and so on an aggravated case, aggravated robbery, 30 years, you have to do 15 years in prison before you're eligible to talk to anybody about parole. And the public still seems to be confused about that, saying, oh, he'll still get out early, he'll still get out early. No, those times have been gone since 1994. The penal code was changed in 1994. You used to could do a fourth. But it's been since 1994, you have to do half of any aggravated crime. So he got arrested in 2012, January of 2012. So it will be January of 2027 before he can even talk to someone. Go to the parole board about getting off. And generally, our clients tell us that they stay about 85% of the time on aggravated cases. And that's for a missing makeup bag and the officer's cousin's wallet that was never mentioned in a 100-page police report. So my director is telling me to wrap it up. So Sam, thank you for sharing your experience.
Thank you for having me.
This case has quite a few other twists and turns. I'm going to push some things back. Please watch it next Wednesday where we take up where we left off. Thank you for watching Truth and Justice with Vivian King. Remember, I want to tell your story. So if you have an interesting story to tell, please call my office or email me, which is better. When the credits wrap up, you'll see my email address and my website. Please go to that and contact me. Thank you again, and I'll see you next Wednesday. Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate